CR 31922. This is a time set for oral argument on a motion to consolidate the matters. Mr. Knapp, this is your motion. Ms. Gouge, I assume, well, very quickly, I guess I'll just ask you your position on it or you're in opposition.
Your Honor, I actually have a matter for the court. At this point in time, I feel that I have no choice but to file a motion of withdrawal on these cases. I will be anticipating filing that later this afternoon. Some things came up this morning that I feel that I have no choice.
All right. Well, I can't address that right now.
That's fine.
Are you prepared to address the motion?
I'm still prepared to address the motion, but I needed the court to be aware of that before we got started.
Okay.
So, Your Honor, my client has asked me to object to that motion because it would be extremely prejudicial for him for a jury to hear all of these, in what are essence 4 separate cases. While they are charged as 3 separate cases, they are actually 4 separate cases. 2 of them had already been joined in an indictment by Mr. Knapp. Some of the facts that Mr. Knapp had put into his memo would be heavily contested at trial, including, in particular, the use of the magnets that the police report alleges. One of the accusations is from an officer who's no longer with the Springfield Police Department, and Mr. Knapp is unavailable. He's unavailable. I haven't been able to find him as a witness. Mr. Knapp can't provide contact information for him. And so that is one of the facts that Mr. Knapp had put into his memo that would be honestly probably contested in a pretrial motion. And that is one of the smaller cases that he's asking to join with all of the 3 of them together. And so there is some separate issues that all of them have as far as identification of Mr. Reason and the officer who's no longer with the force being kind of involved in at least 2 of those cases, Your Honor.
So, Mr. J, I got to ask you, the officer is no longer within the organization and they dropped off the face of the earth. Assuming that's so, how would consolidating the cases make that any less or more of an issue?
Just in particular to those facts that Mr. Knapp stated in his memo, where he's trying to show they're similar in character by the instruments that defendant allegedly used. He wouldn't be able to get some of that information in that trial.
So it's not necessarily a substantial prejudice prong, it's more of they're not similar in nature.
I would agree, Your Honor, and I also think that the identification issue could be potentially a bigger issue, and when you have them all 4 joined and it's an identification issue, I think it's more likely for a jury to ID a potential, the defendant, if they could potentially ID one and not the other. Potentially be a problem to have them all joined, because a jury could easily just infer as one is all 4. So if they've ID'd him successfully, potentially in one case, then a jury could potentially say, well, there's that inference that the jury can make that I think a lot of juries would make when it comes to property crimes, that they could potentially just infer that he's ID'd in all the rest of the cases, Your Honor.
All right, and all right, let me hear from the state on their side of things. And Mr. Knapp in particular, I guess I'm kind of curious as to, well, I'd like you to address that last ID issue argument as well as whatever else you want to address.
Sure. Yes, Your Honor. So I don't have a lot to add to my motion. My position is that these cases is 3 indicted cases that's federally under the statutory requirements, both as being of the same or similar character and being based on 2 or more acts or transactions connected together, constituting parts of a common scheme or plan. Of course, they're not just the same or similar character; they're literally the same crime. They are committed in essentially the same way. They're all shoplifting cases, as opposed to one that might be a home burglary and one where he breaks into a car and one that's an armed robbery. That's not the case. They are all shoplifting cases. They are similar victims. They are similar locations. The intent is similar. The MO is similar. There's of course similar elements in that they are the same elements, with the only difference between the 3 theft 1s and the 2 theft 2s being the dollar amount. The evidence is similar. Each of these alleged counts is all caught on surveillance footage, so that evidence will be quite similar, but also distinct enough as to avoid any sort of confusion. Of the 5 counts, there are 4 different stores. They're committed on 5 different dates. And the evidence is distinct enough that a jury is not going to be confused. And of course, there'll be 5 different security footage segments for them to view to be able to differentiate them. There is some evidence overlap, and as for the identification issue, to give the court an example of really what I'm getting at with this is, in at least 2 of these cases, well, in 2 of these counts, the defendant is caught red-handed. He's caught at the scene and apprehended, so identification is really not the issue in those cases. On the other 3, he gets away at the time, but it's figured out later and put together through surveillance footage. In one of the cases in which he's caught red-handed, he is in and associated with a vehicle that is the same one that he is in and associated with on surveillance footage in one of the cases in which he is not caught on the scene. Therefore, the evidence of that vehicle in the case in which he is caught is directly relevant to identification in the case in which he isn't. It's only prejudicial in the matter that it is not good for the defendant. These cases, additionally, are more than just tangentially related. They are directly related, logically related. Again, they're the same crime. Really, the only reason that they're not already joined on one charging instrument is just the timing of things. Timing of when these cases were committed, when they were charged, when it was time for them to be indicted, and then subsequently new crimes were committed. Were it not for that, these would have just been indicted on the same charging instrument to begin with. Your Honor, the case law is strongly in favor of consolidation under these circumstances. I believe it would be a significant waste of judicial resources to hold 3 separate trials, to pick 3 separate juries under these circumstances. And just as a technical matter, we're here on the state's motion to consolidate. And as for this, the idea of the prejudice and the substantial prejudice against the defendant, I believe that's a different issue. That's an issue of severance that could be brought up by defense and by motion. Unless and until these cases are consolidated, they could then move to get them severed. But that's a separate standard than what we're dealing with today. What we're dealing with today is should they and can they be consolidated into one trial. That's all from the state, Your Honor.
So let me be quiet, check something. I see there's 3 cases. Case numbers, the case ending in 101 and 922 are each thefts in the first degree, single count. And then the case number 1 ending in 842 is a theft in the first degree and 2 counts of theft in the second degree. Which is the one or ones that have, which was the one he wasn't caught red-handed in?
He was not caught red-handed in case ending 101, and in the case ending 842, he was not caught red-handed in counts 1 and 2. He was in count 3, and he was in the case ending 922.
And which is the case that involves the video of him getting in a car, allegedly, and...
Sure. So the same vehicle is used in the case ending 922, in which he's caught, and in the case ending 101, in which he's not. That vehicle will be common evidence that would be shared across both cases. It's a different vehicle used in counts 1 and 2 of the other case.
Bear with me for 1 second, Mr. Knapp. So, Mr. Knapp, you in your motion, you suggested this is part of a common scheme. Other than the fact that there are shoplifting crimes, what evidence is there of a common scheme?
Yes, Your Honor. The case I'm looking at here is Phoebe Smith, 308 or App 639, which talks about that prong C, where they're based on the two or more acts or transactions connect together as part of a common scheme or plan, where it says they fall under that prong if they're logically related and share a large area of overlapping proof, but not if they are only tangentially related and the overlap is slight. And the common scheme or plan, Your Honor, is essentially this repeated effort of shoplifting, of walking into retail stores in the area during open hours when the public is invited in, of selecting merchandise, of concealing it or otherwise disguising it one way or another, and of exiting the store without making any attempt to pay for it.
So you have no other evidence of a scheme other than the fact that they share those elements, is that right?
They share elements, they share facts in common. They are, I don't want to say identical because some of the means of concealment vary, but the overall goals are clearly the same.
Well, I understood one of them didn't involve any concealment whatsoever, right? Supposedly the Fiddler Green one just involves making a pile at the front door and walking out the front door with the pile.
And the state would certainly argue that moving things that he selected off of the shelves and off of racks, making a pile at the front would be certainly concealment. And then you can see him on camera squatting down and trying to hide himself from the camera and sneak out the front door without being seen.
That's never what I've thought of as a common scheme or plan, and it might be similar times, but all right. I'll take a look at 308 or Apple was the end of the site.
639.
639. All right, Ms. Gouge, anything further you want to say?
Yeah, I'm not comfortable getting into all of the facts of this case right now. I do think that there are issues with part of his idea of what makes it a common scheme, again, the magnet issue, and also the different cars used, and he is not identified. I will say that the identification issue is larger than what Mr. Knapp kind of told the court, because a lot, or at least a few of the identifications were facilitated by the officer who is no longer with that department. And so while he's directly involved in one of the counts, he's indirectly involved in at least two of the other counts, and that on that same 1842 case, which would be an issue. And I'm sorry, Mr. Knapp, can you say that citation number again? The last.
It is in my motion.
I know. It's Schmidt, right?
308 or 639.
639. Thank you.
All right, I'll let you guys know later today, or well, one of these set for trial.
The next one is coming up next month, March 22nd. And the next one will be that June 14th date, which defense is opposed to the motion, obviously, but if the consolidation is granted, that's the day that we selected to try all of these cases.
I'll let you know later, probably in the next day or two. Okay, I've got to start a civil trial here in about half an hour, so I'll get to it as soon as I can.
Yes, Your Honor.
All right, thank you very much.